Well, good morning, and thank you for joining us in this panel on an imminence requirement for police. In this panel, we will have Professor Ben Jones and Professor Shannon Brandt Ford. Professor Jones is the Assistant Director of the Rock Ethics Institute and has a PhD in political science from Yale University, where he was a Beinecke Scholar. He does research in moral, legal, and political philosophy and the history of political thought. He is the author of Apocalypse Without God, Apocalyptic Thought, Ideal Politics, and the Limits of Utopian Hope with Cambridge University Press, and co-editor with Eduardo Mendieta of The Ethics of Policing, New Perspectives on Law Enforcement with New York University Press. Dr. Jones currently is working on a book manuscript entitled Making Protection of Life a Priority, The Ethics of Police Deadly Force. This project examines how existing law and police practice fall short of prioritizing the protection of life, a principle found in many use of force policies, and what that principle demands of police and democratic institutions that oversee them. So now I will give the floor to Professor Ben Jones.
Thank you, Daniel, for that introduction. That was very kind. It's great to be here, and especially to be joined by Dr. Ford also. As you'll see as we get into the presentation, Dr. Ford, he wrote an article in Criminal Justice Ethics that came out earlier this year. And the paper I'm presenting is a response to that also will be coming out in Criminal Justice Ethics. And the way academia often works is you write something and back and forth, but sometimes you never meet the person or get an opportunity to actually have a dialogue with them. So I feel really fortunate that we can come together and talk about this important issue in policing. I should say at the start, I'll be focusing primarily on the US context in terms of deadly force rules and policies here. It's what I'm most familiar with. But one reason I was particularly interested in presenting here at the International Criminology Conference and having Dr. Ford on the panel, who's coming from a different context in terms of policing, is hopefully getting feedback on how this issue plays out in other contexts outside of the US. I sort of feel like I have a good sense of where law and policy is here in the US, but sort of going forward, I'm interested in looking at this issue in a more of a comparative context. So obviously 2020 was a year that sparked mass protest and debate over policing in response to the high-profile police killings of George Floyd, Breonna Taylor, and others. And there were a lot of reasons for discontent and for protest, but obviously one of them was police use of deadly force. And the idea that police are using deadly force, at least in the context of the US, too frequently in contexts where it's not necessary, and that concrete steps have to be taken to rein in police deadly force. If you look at data in the US, these data here come from the Washington Post Fatal Force Database, which tracks every fatal police killing or police shooting in the US. And prior to 2020, there have been other mass protests. There was the protest in Ferguson in 2014 after the killing of Michael Brown and many others. And so this issue has been at the forefront of national debate for a while, but we haven't seen any meaningful declines in police fatal shootings. And so you see here from these data, we've been around 1,000 fatal police killings a year, and there hasn't been a meaningful decline. If anything, it's gone up slightly in recent years. And when you compare the US to other wealthy democracies, the rate at which police kill is far greater than our comparison nations. And obviously, there are a lot of factors that can play into that. Probably most notably, the prevalence of firearms in the U.S. is much greater than these other nations, and so that obviously plays a role in how often police use deadly force. Nonetheless, I think there is a growing consensus among use of force experts, as well as the general population, that police in the US use deadly force more often than they should, and that steps need to be taken to rein in police, to limit it in ways that can, without undermining public safety. And so what I'm focusing on, and Dr. Ford will talk about further, is one potential strategy to pursue. And this is not by any means would be a panacea, but potentially one step to restraining police deadly force, hopefully in ways that doesn't undermine public safety. And that would be applying to police what's known as the imminence requirement. And you find the imminence requirement in civilian criminal law governing deadly force by civilians. It's much more common to find it there. And the imminence requirement specifies a necessary condition that must be met to justify deadly force, namely that you have reasonable belief that oneself or another innocent person faces an imminent threat of grave harm. And so it's worth taking a little time to step back and explain what I mean by imminence. And the definition that I'm sharing here, I'm not really trying to do anything new with this definition. You find it in police use of force policies. You also find it in various statutes here in the US. And this understanding of imminence identifies three main components for a threat to be imminent. One, someone with the present ability. Two, someone with an opportunity. And third, someone with apparent intent to cause immediate harm. So what makes a threat imminent is that it's not temporally off in the distance, but it's clearly at hand. It will occur at once unless someone steps in to intervene. And so that's how I understand imminence. What's important to recognize is that the prevailing status quo in both law and policy in the US, as well as many other jurisdictions, is that though the imminence requirement, it's common for it to apply to civilians, it does not apply to police in most cases. And one important decision governing deadly force here in the US was Tennessee v. Gardner in 1985. And what Garner did was it did restrict when police could use deadly force. Before Gardner, in many jurisdictions, there was what was known as the fleeing felon rule. And the fleeing felon rule said that police are legally justified in using deadly force when they have reasonable belief that it's necessary to prevent the escape of any fleeing felony suspect. So they don't have to be a dangerous suspect, they don't have to be a violent suspect, but any fleeing felony suspect. And so in Tennessee v. Gardner, the Supreme Court said that rule is too broad, it's unconstitutional, it violates the Fourth Amendment's prohibition on unreasonable seizures. What's important to recognize, though, is that dangerous is a broader category than imminence as the court understood it. And that really comes out in this passage here from the decision, which reads, if the suspect threatens the officer with a weapon or there's probable cause to believe that he has committed a crime involving the infliction or threatened infliction of serious physical harm, deadly force may be used if necessary to prevent the escape. And what I want to emphasize about that passage is that you could have a suspect that either committed or threatened past violence and is not a present imminent threat. And under this definition, they would still qualify as a dangerous suspect and could be legally liable to deadly force. So prevailing status quo, the imminence requirement does not apply to police. But that said, there are certain exceptions. So there are a number of large police departments, or there's some large police departments here in the US that have voluntarily implemented policies that outline the imminence requirement with regards to deadly force. New York City, Chicago, Houston, also the CALEA, the Commission on the Accreditation of Law Enforcement Agencies. Their model deadly force policy contains the imminence requirement within it. So you do see this even before the protest of 2020. Some agencies had implemented the imminence requirement. In 2020, you had the protest, and in response to that, you actually saw some bills being proposed to apply the imminence requirement to police. There was a bill proposed here in Pennsylvania. It actually was proposed prior to the 2020 protest. It did not pass the state legislature, but in a different state, Massachusetts, there was a large police reform bill that was put together after the 2020 protests. Contains a number of different elements in it, but for our discussion here, it notably also contained the imminence requirement and applying it to police. And so that bill was passed, it was put into law. So this was an example of the imminence requirement, not just being in police policy, but also being in state law. Then this year in 2022, the US Department of Justice updated its use of force policy, and it notably contains the imminence requirement in it. And so this is important because it covers a number of federal law enforcement agents, such as those who work in the FBI, but the Department of Justice policy also can be a model that other departments that aren't bound by it may nonetheless choose to emulate it. So this was a pretty, if we care about the imminence requirement and it potentially being extended to police, this was an important change that occurred very recently. And so the question is this a good idea or not? Is this something that police departments and lawmakers should be pursuing, or should we have ethical qualms about the imminence requirement? And this is where Dr. Ford and I, we differ. And so I'll present my case and he'll be presenting his case shortly. And in the paper that I have coming out on the imminence requirement, it responds to a thought experiment that Dr. Ford raises in support of keeping police exempt from the imminence requirement. And so this thought experiment has two main characters in it, Olivia and Peter. Olivia has a backpack with a bomb in it. This bomb is hooked up to GPS, and basically once she reaches a busy town center, the bomb will explode. It will injure many innocent civilians, and she's a ways off from the city. She drives through a rural checkpoint where police officers there, Peter, and police have good intelligence that Olivia has this bomb, that this bomb will go off when she reaches the city center or this town center. And Peter orders Olivia to stop, to surrender, and Olivia refuses. She drives off, speeds off on the motorbike, and Peter has good reason to believe that if he doesn't use deadly force now to incapacitate and stop Olivia, that she will end up reaching her destination and causing grave harm. And so Dr. Ford, he points to this thought experiment and says, hey, if we don't allow police to use deadly force in a situation like this, where you have a future threat, but not an imminent threat, because Olivia is more than a day away from her intended target, police wouldn't be able to fulfill their responsibility to protect the public. And I think there are a few different problems with this thought experiment. I don't think it actually leads to that conclusion. Let me share some of my objections to it. The first objection deals with whether or not this shows at all that the imminence requirement should specifically apply to police. So you could imagine a slightly different version of this thought experiment where Peter, rather than being a police officer, is an armed civilian. But let's say Peter has all the same information, and he has good reason to believe that he has the only opportunity to stop Olivia before she reaches her final destination. It seems that under that slightly altered version, Peter would be just as justified in using deadly force as if he were a police officer. And so I don't think, because Dr. Ford doesn't question the imminence requirement applying to civilians, and I don't think this thought experiment provides good reason to make a distinction between police and civilians. So maybe you accept that objection, but you'd say, hey, well, maybe the imminence requirement shouldn't apply to anyone. It shouldn't apply to police, nor should it apply to civilians. And I think that's a much stronger conclusion, and that because the imminence requirement applying to civilians is long established, though it's not universally accepted, it's broadly accepted by many individuals and by our legal system. And so I think it's good to take a step back and understand the rationale behind the imminence requirement. And so the imminence requirement traditionally has been understood as a proxy for necessity. And so, because you don't want to use deadly force unless it's necessary to prevent some sort of grave harm. And when you have a non-imminent threat, that means the threat is not as temporally close as an imminent threat. And so for a non-imminent threat, there's a lot more opportunity for things to intervene and do away with that threat, so that if you use deadly force against a non-imminent threat, there's a greater risk that your use of deadly force will be gratuitous and ultimately unnecessary. And it's very difficult under real life conditions, aside from the sort of neat thought experiments that philosophers like to make up, to know whether or not a non-imminent threat is actually going to be realized. And so what we often find in the law is that the law says, hey, we don't want civilians making those types of decisions because of all the uncertainty involved, because of the risk of unnecessary force being used. And a final sort of problem I'll raise is there have been a number of critiques raised against the imminence requirement, not just in policing, but with regards to civilians also. And the strategy that's often used is offering a thought experiment like the one that you find in Dr. Ford's paper. The problem is that the conditions of certainty are often much higher in those thought experiments than what almost is ever found in the real world. And what's interesting, there's a paper that came out a few years ago by Fritz Allhoff that was critical of the imminence requirement. And he also offers a thought experiment trying to critique it. But in that paper, he himself admits that actual cases simply do not exist, end quote, where defensive force is necessary despite no imminent threat. And so what these thought experiments try to do is come up with conditions where necessity and imminence come apart. And you can come up with those types of thought experiments, but it's much harder to find actual cases where that's true. Now, what defenders of the imminence requirement have going for them is that it's not hard at all to come up with actual cases where police or civilians use deadly force against a non-imminent threat, and it turns out that force was in fact unnecessary. And so that was force that from a moral perspective, we didn't want to be used. Oops, I'm going the wrong way. An example from state where I am, Pennsylvania, this is from a few years back. This was a pretty high profile case. It was caught on video, the police shooting of Antoine Rose. And this was a case where Rose was in a car that was involved in a drive-by shooting. Evidence later came out that Rose himself was not the shooter. Police pulled over the car, and after they pulled over the car, Rose sprinted out of it and he fled. And the police, he was fleeing, and there's no evidence right there that he was an imminent threat. They didn't see that he was armed, but nonetheless, they used deadly force and they shot and they killed him. And this was an instance where he wasn't armed, he wasn't a grave danger to anyone. And if the imminence requirement had been followed, we could have avoided unnecessary deadly force. And there are other examples like this. And so no policy is going to be perfect in terms of always recommending the morally optimal outcome because of uncertainty and because of, because of uncertainty and because of reasonable mistakes. But when we have to make these tough choices about what sort of, where do we want to minimize harm? Do we want to minimize harm in the thought experiments or in these actual cases? I think there's a pretty compelling case that we should really focus on what seems to work the best in actual cases. There are a few other reasons that I think morally exempting the police from the imminence requirement is on shaky ground. So the first reason is the principle of equality before the law. And this is a broadly accepted principle in moral and legal theory, and the basic idea that the law should treat everyone equally. And what the imminence requirement, when you exempt police from the imminence requirement, what that in effect does is that it provides police with more expansive permissions to use deadly force. It treats police differently than civilians. Now, equality before the law is not a categorical principle. I think it should be understood as a presumption, and there can be cases where there are compelling reasons to override that presumption. And potentially there are cases where the law should treat police differently than civilians. But for that to be the case, we have to look at all those different potential exceptions and see, are there compelling reasons for that exception and to override the principle of equality before the law. And the problem with exempting police from the imminence requirement is that we don't have any research showing that police are reliably accurate in these, because when police use deadly force against a non-imminent threat, they're having to make predictions about that suspect's future dangerousness. And we don't have any evidence that they're reliably accurate in those predictions or that they're better in those predictions than civilians. And so when police operate under an exemption from the imminence requirement, they're doing so without evidence-based practices or training to guide their decisions. And I think that makes the prevailing status quo very problematic from a moral perspective. Another point related to this is, in other contexts in the criminal justice system, future dangerousness predictions are made. One example in the US is capital sentencing. So in a number of jurisdictions, to be able to sentence someone to death, it's required for the jury to find them a future danger, or sometimes that's an aggravating factor in deciding whether or not the person should be sentenced to death. And there's been a lot of research on these future dangerousness predictions, and they have been found to be wholly unreliable. And this is a context where there's time for deliberation, there's time to step back and decide whether or not this person's a future danger. Police will have to make these decisions under much different conditions, under duress, without the opportunity for deliberation. And I think that should give us pause on their ability to make these decisions with reliable accuracy. And then the second principle I want to focus on, and you find this throughout the literature on the ethics of defensive force, is the doctrine of doing and allowing. And so a broadly recognized principle is that it's more morally difficult to justify doing harm than allowing harm. And this is relevant for the debate here because the imminence requirement favors different types of errors than the prevailing status quo. So the imminence requirement is a more stringent rule on police use of deadly force. And so it comes with a greater risk of false negative errors. That is, police falsely believing that someone's not a future danger, not using deadly force, and that person goes on to cause grave harm. In contrast, the prevailing status quo comes with a greater risk of false positive errors. So that's mistakenly identifying someone as a future danger, using deadly force against them when in fact it was unnecessary. And what the doctrine of doing and allowing tells us is that, all else being equal, false positive errors are worse than false negative errors. And so given that the prevailing status quo favors those types of errors, that also puts it on morally shaky footing. Now, if it were the case that the prevailing status quo came with slightly more false positive errors, but dramatically prevented a great number of false negative errors compared to the imminence requirement, then there could be a compelling moral case for it. But we don't have that research, any research indicating that. And so that's another reason that I don't think the prevailing status quo, the moral case for it, is particularly strong. Now, what I'm mainly trying to do in this paper is to show that the imminence requirement is not inherently in conflict with police responsibilities. And that for police agencies and lawmakers that want to pursue this, they shouldn't have moral qualms about that. That being said, it's still a relatively novel policy and practice, and it needs close research. And that research will give us a better sense of, is this the morally optimal strategy or not to pursue? And I think a helpful analogy, and hopefully pursuing that research, is the research that was done around the fleeing felon rule decades ago prior to Tennessee v. Gardner. Because prior to that decision, you had a number of police agencies and jurisdictions that had abandoned the fleeing felon rule. And what criminologists did was they closely studied the effects of that change. And what they found is that it reduced police shootings without jeopardizing public safety. And if similar research can be done now, and it finds similar results for the imminence requirement, that would bolster the moral case for it. And then lastly, I think it's important to I focus primarily on the United States, but I think there should be more comparative work and looking at, has the imminence requirement been implemented in other places around the world? What have their experiences been with it? So thank you very much for the opportunity to present. I look forward to Dr. Ford's presentation and questions after that.
Thank you, Professor Jones. Next, we will have Professor Dr. Shannon Brand Ford. He is the coordinator of the International Relations undergraduate major at Curtin University in Perth, Australia. He is also on the board of directors for the Asia Pacific International Society of Military Ethics and a faculty affiliate with the program on cybersecurity and internet governance at Indiana University. Previously, Dr. Ford was a visiting fellow at the University of New South Wales, Canberra, and a research fellow with the Center for Applied Philosophy and Public Ethics. He has taught a range of undergraduate and postgraduate subjects at Curtin University, the Australian National University, Charles Sturt University, and the Australian Defence Force Academy. He has also developed and taught professional development programs for government agencies in international security, intelligence, and policy-making processes in Australia and overseas. I will now pass the floor to Dr. Ford.
Can you hear me okay? Can you see me?
Yes, yes.
Yes, okay. And you can see the presentation?
Yes.
Oh, very good. Okay, well, thanks for the introduction. And thanks also to Ben for inviting me and writing a response to my article as well. I see that as a very, very encouraging thing for an academic. I look forward to following up on this discussion as well. So it was a very useful process to go through and look at the article that Ben wrote. I'll do what we always do here in Australia. We acknowledge the Whadjuk Noongar people as the local Aboriginal people, traditional custodians of this land, and pay my respects to the elders past, present and future. What I want to do today is just talk a bit about what my article was saying, and then respond to some of the points that Ben's made as well. And I'll start out by looking at the focus of the article I wrote really being about restraining police use of lethal force. So I think Dr. Jones and myself are very much on the same page in that respect. Then I'll kind of discuss a bit about what Ben has said in his what I call his imminence-centered critique, and then hopefully give a couple of responses to the criticisms that he's made of my work. And what I'll do then is I'll add two additional cases, so real cases, which I'm hoping will clarify some of the points that I made in my article as well. Okay, so the purpose of my recent paper was really to demonstrate that the principle of restraint is inherent to the policing function. So my argument there is to say that policing ought to default to a standard that emphasises the minimum use of force necessary for police to effectively preserve public safety. And that this the judgment for doing this is the principles of necessity, proportionality, and discrimination. So the goal really of the paper and my thinking around it was about how can we reduce things like police shootings. I argued that there is a significant ethical distinction between justified killing in self-defence and police use of lethal force. So that was the fundamental argument that Dr. Jones has picked up there is the fact that I don't give the same weight to imminence that he does, and that's very much where he's come from in terms of the imminence focus. But my primary focus was just trying to say that there was reasons to think that there's a difference between the police and the average person when it comes to using force. And the point was that police officers have special permissions to use lethal force based on their state-imposed duties. So because the police have additional duties in their role, that also gives them additional permissions in the way that they can use coercive force. And the moral reason for these duties are derived from their purpose to preserve public safety. And I concluded, as part of that discussion, and this is the fundamental part of it, part of the discussion really was that police are obliged to go to greater lengths than non-police to avoid the use of lethal force. And really, it was the concern there was about the militarisation, or seeing the militarisation of the police role, particularly in places like the US and Australia. I mean, I think it's a very useful process to look at this sort of comparative analysis and thinking about differences between the US and places like Australia. It was in reading Dr. Jones's article, I was surprised that he described my perspective as the status quo perspective. When from the Australian perspective, the kind of the self-defence argument or the imminence requirement is kind of standard thinking, I think, for Australian police officers. Now, it might be argued that the best or perhaps only way to reduce police shootings is to strictly apply a self-defence paradigm. So that is, police only use lethal force when it is necessary to fend off an unjust, immediate, deadly threat to themselves or to the lives of other innocent parties. And so that's what I take Dr. Jones is arguing. So the simple example there is the police are permitted to shoot an attacker who lunges at them or an innocent person with a knife. But they shouldn't shoot an unarmed person, unarmed suspect fleeing the scene of a crime. Now, the point in my article, the argument there is I raised two problems with this approach, right? So what I refer to as the self-defence paradigm as it applies to the police. And the first kind of problematic issue I raised there was that the self-defence paradigm overlooks the duty of police to proactively protect the public from dangerous criminals. So the unarmed suspect fleeing the scene of a crime might be someone who has just committed a mass shooting and is running away, having dropped his weapon. And that police cannot simply allow the unarmed shooter to escape. So the example, besides the thought experiment, the follow-up real-life example I gave was the case of the 1982 assassination attempt on the Israeli ambassador in London, where one of the protective officers who was there trying to defend the Israeli ambassador chased after the assassin after he shot the ambassador, chased after him and shot him to arrest him. And that the argument there in the follow-up trial was, at least the judge said that, even though it wasn't a case of the assassin being an imminent threat because they were running away, the gun had jammed, it still was the right thing to do for the police officer to shoot the attempt of the assassination. So police are duty-bound to intervene, or the conclusion I had was that police are duty-bound to intervene when they suspect that a person is a serious threat to public safety. Police have a duty to preserve public safety within their jurisdiction. So the police use of lethal force goes beyond warding off an immediate threat. And the reason is because police don't have the option to walk away or hand the problem off to somebody else, right? So when it comes down to it, ultimately, the police are the ones who are responsible for addressing people or addressing dangerous criminals within the community. Now, the other aspect that I talked about there, or second problem I had with the self-defense paradigm as it applies to the police is that it might actually demand less restraint in using lethal force than we should expect from police. As a rule, police accept greater risks to their personal safety than the average person. So what the average person reasonably believes is an immediate threat to his life should be interpreted differently by police. And I think this is where there's a very different understanding between myself and Dr. Jones, is that his assumption there is by applying the imminence requirement that the police are going to be more restrained in their behaviour. But I think we should expect police to look at situations differently because of their training, equipment, and organisational support as well. And that should lead to less use of lethal force. We should expect the police to demonstrate more restraint in the way they deal with threats. So really, I'm trying to come to the opposite conclusion of I guess what Dr. Jones is claiming that I'm saying. This means police should demonstrate greater reluctance to use lethal force when personally threatened than the average person acting in self-defence. And the more important consideration for police is the threat to public safety. So the threat to public safety is the primary thing before they think about the threat to themselves, okay? Now, thinking about, I'm reading through this week Dr. Jones's excellent article. He defends the imminence requirement as a necessary condition for justifying police use of deadly force. The reasonable belief that oneself or another innocent person, what he's saying here is that the reasonable belief that oneself or another innocent person faces an imminent threat of grave harm. So that's what he's talking about in terms of imminence. Jones's aim is to reinforce the adoption of the imminence requirement as standard policy for US agencies and reduce the number of police shootings over against what he calls the status quo view. He argues that there is little empirical evidence that exempting police from the imminence requirement that actually benefits public safety, and that it conflicts with core principles in ethics and law. So that's the sort of summation of what I see his argument being. Now, really, I think it's very clear that we both agree that the goal is better public safety and fewer police shootings. I think that's what we're both aiming to. That's very important. And that certainly further empirical research on the imminence requirement is necessary to properly evaluate its impact on policing and public safety. So this is something, in terms of the conclusions that Dr. Jones came to, I would encourage that. So I'd say that this is an area where we should be doing more research and thinking more, looking at actually empirically what the results are. So very important area. Jones argues also that the law should reflect equality by giving individuals equal protection, and that exempting police from an imminence requirement undermines this fundamental principle. Now, I agree that police shouldn't be given more leniency than non-police, right? So it shouldn't be the case that because someone's a police officer, that we treat their use of lethal force in a more lax fashion, or that we're more forgiving than we would be for a person who's not a police officer. But that's the point of the article I wrote, is that is to actually lean in the other direction, right? It's to say the opposite of that. If I'm saying there's an unequal treatment, it should go the other way, right? That additional powers that the police have should mean that police are held to a higher standard, not the other way around, right? So I would hope that I'm not, if I am advocating a different approach or inequity of treatment, that it would lean towards a stricter interpretation of the police use of lethal force. The second major area of disagreement or criticism was the fact that Dr. Jones puts emphasis on demonstrating that what justifies the use of lethal force always comes back to imminence in some way. So the article that I read in response to mine basically was able to kind of show that the examples that I used really, where they're justified, they really come back to imminence at some level, ultimately. And certainly, and they're very good arguments, and I agree that the imminence requirement is frequently a good proxy for necessity as well. But the danger I see, or the risk in Dr. Jones's argument, is of using imminence as a synonym for necessity. So it's not very clear to me how imminence is different to necessity. That essentially that Dr. Jones is using imminence as another way of saying necessity. Well, they're basically they're the same thing. And so it's an interesting question to sort of say, well, is there actually a difference in this case between necessity and imminent ultimately? And he mentioned Fritz Ohlhoff's 2019 article, where I think, having then read Ohlhoff's article, I think he makes a convincing case that we can distinguish between necessity and imminence. So that's his main argument there, is to say, well, can we actually pull these two things apart and look at them as different things? And that his point is that in doing that, necessity actually takes precedence. And so I tend to agree with that perspective, Ohlhoff's argument, ultimately that really that imminence is a good proxy for necessity, but really the thing we're interested in is cases where it's necessary to use lethal force. And I also take Dr. Jones's point about the examples that I use, that essentially says that my thought experiment is making an argument that in some cases that imminence is actually not necessarily required for non-police as well, right? So the sorts of scenarios we can come up with, thought experiments that would apply to a police officer would also apply to someone who's not a police officer. And I think that's really what Ohlhoff's article is about, is thinking of using case studies in law to examine situations where people who are not police, things like battered wives and someone who's in a prison that can't escape, someone who's going to kill them. He's looking at these various cases of self-defense and saying, well, there are cases. It seems like it's ethically right that where something is it's necessary to use lethal force, that they should be allowed to. And as much as I'm sympathetic to that, the very noticeable thing in Ohlhoff's arguments is that there's always exception unless there's some sort of authority that person can turn to. So in the case of battered wives syndrome, women's syndrome, he talks about the fact that, the question is always asked, could that person being battered, could they have gone to the police and could that have solved the matter, right? So really, was it necessary? But the point is that there's got to be someone who sits behind that who can make that judgment. So that there's got to be something that sits behind that requirement as well. So you can think of cases where the police aren't doing their jobs, or the police are not available, or some other case. And so I'd be open to that argument that if lethal force by a non-police officer was necessary, that you can make that argument, right? But the point would be, when Dr. Jones talks about this person who wasn't a police officer, if Peter wasn't a police officer, well, he would surely he'd be able to have the permission to shoot the bomber. Well, what he could also do is he could call the police, right? So that'd be the thing, right? So rather than try and take it upon himself, he could also just get in contact with the police and tell them, give them the description of who this person was. And I think that would be a requirement in that particular case. Anyway, so that's all to say that importantly, we have no reason to think, I would argue that we have no reason to think that necessity is a less rigorous requirement than imminence. So I think that's a really crucial point there, is that I think that that necessity, there's no reason, necessity is still a rigorous concept, I think, even if imminence is not necessarily there as well. And I don't think it's very hard to think of cases where, this is the point of the Ohlhoff article, cases where you take imminence out, but something is still necessary. Imminence does help make clear necessity in practice as well. It is a good heuristic or rule of thumb that can be broadly understood, easily understood by a variety of principles. And this is where I think the power of the imminence requirement comes through. In terms of the doing versus allowing harm critique, this says that it should be more difficult to justify causing harm than allowing it. Allowing police to shoot a fleeing suspect who is not an imminent threat comes with a greater risk of false positive errors, is the argument there. So that is, I take this to mean using deadly force against a suspect mistakenly because they wouldn't have done future harms, right? That's what we're talking about. It's a bigger mistake. But my response there would be to say that police have responsibilities for public safety that give them less discretion about doing versus allowing. So you can say for the average person that that distinction is really important, but the point of police having this responsibility for public safety means that they don't have that same level of discretion about allowing harms, right? We have a stricter interpretation of or requirement of police getting involved or intervening that we don't have for non-police. And the other thing too, I'd say is that we should keep in mind that not all cases are fleeing suspects as well. And I'll demonstrate that below in the two additional cases I've got here as well. Dr. Jones takes my paper to task for starting my analysis with a thought experiment, which is a very common thing in ethics and philosophy to use thought experiments. And he arguing that critics of the imminence requirement focus on harms confined to thought experiments. And certainly he makes a really good point that my thought experiment cast out on the imminence requirement generally, not just police, but I've sort of talked a bit about where I think I can patch that up. I still think, though, I'm not a philosopher by any stretch of the imagination, but I think plausible thought experiments have some value for eliciting fundamental moral intuitions to get us thinking about something without some of the emotional attachment we have to real cases as well. But I'll address both of these criticisms with these two additional real life cases below. So just very quickly, because I know we're going to finish up soon. The first case I want to look at, real life case, and so this is a world first. So Dr. Jones says that no one who sort of defends the status quo argument has ever used a real case. So this is going to be a world first to do this. 2014, there was an individual called Manharon Monis who held hostage 18 people in the Lent Chocolate Cafe in Martin Place in Sydney. This led to a 16-hour standoff between police and Monis. During this period, 12 of the 18 hostages managed to escape. But then around about the 16.5-hour mark, the hostage, Tory Johnson, who was the manager at the Lent Cafe, was unfortunately, sadly executed by Monis. Then when that shooting occurred, the Tactical Operations Unit jumped into gear, went and stormed the cafe. And in the process of storming the cafe, hostage Katrina Dawson was also killed by a police bullet ricochet. And obviously Monis is also killed. 3 other hostages and a police officer were injured by police gunfire. Now, in the coroner's investigation of what happened in the siege, police were criticised for not taking proactive action earlier. So police snipers were in position, and it could have shot Monis. So they certainly had a number of occasions where I think it was 3 police snipers in position. A number of occasions where they could have shot Monis and ended the siege. And the question is, well, why didn't they? Given the disastrous result? Well, the New South Wales Coroner's report said the snipers and the police commanders believed that police did not have lawful authority to shoot Monis because he did not pose an imminent or immediate danger to the hostages. So here's a case where really waiting for the imminence requirement led to the death of 2 hostages and obviously several injuries. Monis posed an unreasonable culpable risk to the hostages' lives. this should have been sufficient to justify the police snipers shooting Morris when they had the opportunity on the basis that it was necessary to protect the lives of hostages. Now maybe this mistake is, in a sense, a positive thing about police culture in Australia. I don't think the status quo that Dr. Jones describes is at all the status quo for Australian police. I think Australian police are very rigid about the application of lethal force having an imminence requirement. But the point is to say that this particular case, and there were a number of other factors behind him. The police were worried that he might have made a claim that he had bombs in place if he was shot. They weren't sure if there was a bomb strapped to Morris himself. So there were some other factors there, but it was very clear that they didn't want to shoot him, which would have ended the siege and saved the lives of those two people, rather than rushing in there in a much more dangerous fashion. The other case I want to use to illustrate the important distinction between what the police can do and what the average person can or shouldn't do is the Kyle Rittenhouse shootings in 2020. Now, I don't want to talk too much about the actual describing the case, because I'm sure the audience in the US will know a lot more about it than I will. But I'll just quickly say Kyle Rittenhouse shot and killed 2 men and wounded another man in Kenosha, Wisconsin. Shootings occurred during the protest that followed the shooting of Jacob Blake by police. Rittenhouse was at the protest armed with a high-powered automatic rifle. And that what unfolded was one of the protesters, Joseph Rosenbaum, grabbed the barrel of the rifle, Rittenhouse's rifle, and Rittenhouse shot him 4 times. Rittenhouse tried to then run away towards a line set up by police about 3 blocks away, but some of the crowd followed. Rittenhouse shot and killed Anthony Huber in a scuffle and wounded Gage Grosskreutz before escaping. Now, really the question here is, why was Kyle Rittenhouse there in the first place? Well, Rittenhouse had joined a group of armed men who said that they were in Kenosha to protect businesses. And a reporter on the ground got these quotes from him before the shootings. "Our job is to protect this business," said the teenager says to a journalist, gesturing to a car dealership behind him. "And part of my job is to help. If there's somebody hurt, I'm running into harm's way. That's why I have my rifle." As I said, Rittenhouse should never have been attempting to act in the police role. Whatever we might think of Rittenhouse's motivations, positive or negative, his lack of policing expertise caused the death of 2 people. And this says to us that some situations should be handled by the police, and our obligation is to get out of the way. So this is where we go back to Dr. Jones's criticism of the thought experiment. If Peter wasn't a police officer, he would have the same permission. Here, I'd say the responsibility for Peter would be to actually notify the police so that they could do their job. In conclusion, certainly, look, moral judgments involving the use of lethal force are hard. And so it's a very difficult area, both practically and theoretically as well. So I have a lot of respect for people who have been in these situations, having to make these decisions. And certainly the imminence requirement in self-defence is an effective proxy for necessity. So in that respect, if that's going to help reduce the numbers of police shootings in the US, then I think we'll agree that that's a really important thing. I think the imminence requirement is a heuristic or a rule of thumb that can be broadly and easily understood, and this is what makes it effective, right? So it's something that people can understand, and it's got some easily, and it's got a high degree of or reasonable degree of rigor attached to it. But the problem is that police have additional responsibilities. So it's not just waiting for. They can't just wait for the imminence rule or the imminence requirement to appear before they can act. Well, it reminds me, of the movies. The good guy stops the bad guy, but then he refrains from shooting him because that'd be the wrong thing, and then he starts to walk away, and the bad guy pulls out a gun, but then he can shoot him, and it's okay. So it's only when the the bad guy actually goes for his gun, that we can say that it's okay to shoot him. Fact is, the police just had these additional responsibilities to address dangerous issues and dangerous situations and dangerous people. And my point would be that those police officers can and should be trained to have a more sophisticated understanding of necessity. So I think it's quite when we talk about necessity, when we talk about imminence as applied to self-defence for the average person, again, the rule of thumb is a good one. But when we're talking about professional police officers, they can be trained to have a much more sophisticated understanding of necessity and the kinds of different types of scenarios that you should use force and where you shouldn't use force as well. So when we talk about Antoine Rose's case, for example, in 2018, there's no way that he should have been shot. There's no way that should have been a permissible action by police, because as a person, a criminal who was running away from a stolen car, there was no reason at all. And I think having a better understanding of necessity is something that we can train police officers in. And that's all I've got for now. So thank you very much for your time.
Thank you, Professor Ford. Some of those examples were very interesting in that they illustrate precisely the complexity of real life situations in which police officers are, counting on seconds, minutes to make quick decisions. And that may lead us to one of the questions here, which is for both panelists. It's a couple of questions. Might there be a middle ground between having an imminence requirement or not for police? It would seem that most real life situations are too complex for an accurate calculation of risk. How do we manage subjective perceptions of risk?
Ben, you want to go first?
I can take a shot. I mean, it's a great question. And in defending the imminence requirement, I don't want to imply that there's still going to be tough cases in terms of whether a threat is imminent or not. And how I would respond to some of the real life cases that were brought up is, I think those were sort of tough calls on whether or not the threat was imminent or not. And, with the imminence requirement, what it does, what I showed up on the screen in terms of how it's been defined by police training policies and also in the law, is that it gives three sort of concrete criteria to see if they're mentioned. Does the individual have the opportunity to carry out grave harm? Do they have the ability to do so? And then do they have the apparent intent to do so? Now, that last criterion that's something that's in their head. And so it's hard. Obviously, they can make movements. There's ways that they can act that you could infer that they have the apparent intent, but that's still going to be sort of a tough thing. And that's why inevitably there's still going to be tough cases. What I see as I do believe that police should have certain exemptions with regards to the rules governing deadly force compared to civilians. And where I think an exemption should be made is, though this has become less and less true, sometimes a duty to retreat still applies to civilians with regards to using force or using deadly force. And I actually think that is a good restriction that should be on civilians if the priority is protecting life. But I don't think that requirement should apply to police, because their duty, if there's a threat to public safety, the responsibility of police is to address that threat, to pursue that threat. And so that's where I sort of see, hey, here's a place where there is a compelling reason to exempt police. But I think I see the case as less strong with regards to imminence.
Thank you. Dr. Ford, would you like to add anything to that?
No, I think Ben's answer was very good.
Thank you. Another question in terms of research, is there a country or countries in particular that might fit a comparative study with the US justice system? I gather this is related to the need for future research about comparing situations where the imminence principle has been required or not, and the consequences of that. I would add to that, considering the graphs in Professor Jones' slides at the beginning, the difference between people killed by police between the US and other countries is a big difference. So is there a country or countries that might fit a comparative study, and might there be any challenges in that sort of comparative study, considering the US situation might be sort of unique?
Well, probably. I mean, something that would almost disprove my own argument would be my own country, right? So I've said that the status quo in Australia does require the imminence requirement, right? So that's seen as being a necessary for the police use of police use of lethal force. So if there's a strong argument against what I've said, it would be my own country. It would be Australia, I think. But again, I mean that. There's two aspects to that. One is that's a lot to do with just a much stricter idea of guns in general, right? So we have a much less of a toleration of guns in our society anyway, and there's still very much is an acknowledged racism issue where police shootings are disproportionately against Indigenous people as well, and so there's very much a recognised problem there, and that's tied in very much with the sort of issue of racism and the issues around Indigenous people in Australia.
Before responding, I have a question for you, Dr. Ford. The imminence requirement in Australia, does that show up at agency policy level, federal law, constitutional law, all the above?
That's my understanding. I'm not a lawyer by any stretch of the imagination, but yeah, I mean that's the police that I've talked to about these types of issues. It's very much how they think about the issue. It's very much a strictly you need to see, well, the sense, you only use lethal force in self-defense or defense of others when there's an imminent threat.
Mm-hmm.
Yeah.
I can't find the site now, but there's a recent, I don't know how recent it came out, but there is an online site that's been trying to document the different legal standards that apply to police use of force internationally. And so I'm interested in sort of digging into that a little more, maybe being in touch with the folks that have put that together to see, where does this imminence requirement show up and where doesn't it show up? I think, comparing the United States to other countries is very difficult because there are obviously unique conditions here with how much greater risk there is of encountering suspects with firearms. That said, I think there's the Police Executive Research Forum that's based in DC here. And I know a lot of their work, they've gone to the UK and have studied police there. And particularly looking at, because police in the US use deadly force, hundreds of people are killed in the US each year who don't have a gun, that have a knife or, some other have a blunt object. And, police in the UK are trained typically not to respond to deadly force for aggressors that are armed in that way. And, a knife in the UK and a knife in the US isn't going to be terribly different from each other. And so I think, especially when we're trying to lower deadly force against suspects that don't have a gun, I think there can be a lot of valuable lessons drawn elsewhere because, those threats aren't going to be that different than the threats here in the US.
Thank you. We don't seem to have more questions, and we're running out of time. So we will end this panel. And thank you, Professor Jones, and thank you, Professor Ford, for joining us today. And we hope to see everyone in our next sessions. Thank you.
Thank you very much.
It's fine. Thanks.